The next matter to come before the court this morning is Gabriella Denkewalter versus Jack Denkewalter. Each side, the appellant may have up to 15 minutes to argue. We have read the briefs and we're ready to see when you are.
Thank you, Your Honor. Good morning. Judge Carr, Judge Kenzel, Judge Whitmore. My name is Cheryl Lukacs. I'm from the Lukacs Law Firm. And it's my pleasure today to represent Gabriella Denkewalter, now known as Moir. And if I may, Your Honors, throughout my argument, if I could, as I did in my brief, identify the parties as either mother and father, since this is a custody parenting issue that you have before you. Your Honor, Mother brings today 5 assignments of error, 2 of which address and are based on an abuse of discretion standard, 3 of which are based on jurisdictional, perhaps constitutional issues. And if I may, I'd like to begin with the jurisdictional issues, as they may be dispositive of this entire appeal. And those are assignments 2, 3, and 5. In assignment 2, what Mother argues is that the filing of any motion gives rise to the court's jurisdiction, and that is true of the Domestic Relations Court, both here in Medina as well as in Summit County. Conversely then, dismissing a motion would sever the court's jurisdiction in this matter. And what we discovered in the court's last order was that it dismissed Mrs. Moir's motions. It did so first with prejudice, and then upon objection, affirmed its dismissal of the motions, however, changed it to without prejudice. And then it ordered continued counseling for the child. Mrs. Moir submits that the lower court had no jurisdiction to order counseling after it dismissed all of her motions. Said dismissal appearing to have severed the court's jurisdiction for that moment. In our assignment number 3, Your Honor, again, it's a jurisdictional matter having to do with whether a court has jurisdiction over the person without service. Mother argues that in divorce matters, Civil Rule 75 requires that service of all post-decree motions in domestic relations matters must be served by pursuant to Civil Rule 4. Father filed a motion to continue counseling after the court dismissed, after the court dismissed, but while objections were pending, Father filed a motion to continue counseling. The lower court heard the objections and ruled on the objections, again affirming the dismissal, modifying it to without prejudice, but then affirming that there would be counseling. Mother's position on this is she was not properly served. The docket will show that there's no instructions for service. There was no certified mail service, no personal service, no sheriff service. Mother never waived service in this matter. There was never a hearing held, and the court, after dismissing all of Mother's motions, ordered that counseling continue. The last assignment of error that deals with the jurisdictional matter is number 5, where it relates to an issue that was actually raised by this court, and we appreciate the court's astuteness in raising that issue. It's an issue with regard to whether any or all jurists who may have heard matters in the lower court, may have signed orders in the lower court, may have issued other kinds of decisions or opinions in the lower court, were properly assigned. In this case, this matter originated in the Medina County Domestic Relations Court. Judge Kovac was the presiding judge in that matter. Father filed a motion to remove magistrates and judges alleging irregularities or improprieties. 7 days later, Judge Kovac recused herself and asked that the Ohio Supreme Court Chief Justice assign another judge. And in fact, the Chief Justice did just that and assigned Judge Carol Dezo of the Summit County Domestic Relations Court. Thereafter, many proceedings occurred where Judge Kovac signed orders assigning. Judge Kovac of the Medina County Domestic Relations Court signed orders assigning magistrates from the Summit County Domestic Relations Court.
And that was done after Judge Dezo was appointed?
Yes, it was done.
So Judge Kovac had no authority?
That is our position, Your Honor.
Okay.
And she did that for 2 magistrates. 3 magistrates have heard this matter over the course of a period of 5 years, I believe. Judge Kovac signed orders for 2 of the magistrates. The 3rd magistrate that heard matters, no order was issued.
Were any objections made? I understand who's on first and second may have been difficult for people to keep track of, but were there any objections to what was going on at the time?
There was not.
Everything was just taken at face value?
I'm afraid it was, Your
Okay,
Honor.
thank you.
And of course, when it was raised to us, and as we began to review this for appeal, naturally we wanted to try to do whatever we could to remedy it and raise it now.
Now, you're talking in that assignment area about the jurisdiction of the trial court. Now, but I'm interested at this point, for me personally, about the jurisdiction of our court.
Yes, Your Honor.
So you started out by saying, because we had issued a show cause order for you, that one of the issues is, when you're talking about your jurisdiction issues, one of the issues is pertaining to jurisdiction of this court as dealing with the fact that the court dismissed the motions without prejudice.
Yes, Your Honor, and as a matter of fact, that issue was raised by this court, and we were invited, a father and mother were invited to brief that issue.
Mm-hmm.
Mother submitted a brief, father did not. And it is
father has agreed with the reversal.
Father has agreed with your reversal,
So
yes.
he's not contesting anything.
It appears so.
Okay.
So in terms of a final appealable order, it's a twofold test. It's whether first, this is a special proceeding, and whether there's a substantial right. I believe that this court has already determined that a custody matter in a domestic relations proceeding is a special proceeding, and mother agrees with that position. It is the substantial right that becomes a little murkier, and in our brief, we identified several matters that we believe is a substantial right. Custody, of course, is a substantial right. When the matter was pending, temporary orders were issued that provided that mother had temporary custody of the child and that the children, and that the parenting time between father and the children would be either in a therapeutic setting or upon agreement between children who are teenagers and father. So she lost that finding. She also lost...
But the point is, she could just refile her motions.
And then she would fight again to and have other hearings to determine who has temporary custody. There were other matters that were ordered by the court that affected a substantial right for mother. For example, in her original order, she was to pay 10% of out-of-pocket medicals. The temporary order said 50%. It was a 40% increase. That was something that she should have had an opportunity to appeal. She lost her claim for attorney's fees, 16 months worth of attorney's fees. Access to the children's medical records were a loss to her. Continued therapy of a minor child. The original order indicated that mother had say over the medical. But more importantly, recently in King v. King, the issue of whether a person would have to refile, pay the filing fees, and take that kind of loss was issued from this court, indicating that that could also be a loss and a substantial right. But in King v. King, the lower court assigned a guardian ad litem. It appeared in perpetuity, and that is what we have here in terms of therapy between father and the minor children. It appears as though we have the last parenting order of the court, and the last parenting order of the court states that the children shall attend therapy or continue therapy with the father. And that appears to be in perpetuity. Moreover, there are a number of elements to that kind of order of determining whether the parent and the child should have therapy, and there was no provision, Your Honor, for who would pay, no provision who was obligated to bring the child, to transport the child, no provision for how often. So these kinds of provisions were left out, and everyone seemed to be left at 6s and 7s on their own to figure out what that order meant. So based on that, it is our position that this court does have jurisdiction and that this is a final appealable order, Your Honor.
Thank you.
The remaining assignments of errors, 1 and 4, deal with an abuse of discretion, particularly dealing with Civil Rule 41B in terms of the court's ability to dismiss with or without prejudice. Typically, that is a kind of situation, Your Honor, where some party has not done as the court has required, whether it be to attend a hearing, whether it be to submit some sort of discovery. In other words, some party has put themselves in the perilous position that if they do not do which is required of them within the setting of litigation, that they risk having their motions or their action dismissed. There's a sense of justice in that, I would expect, because you're put on notice. If you come to a court and if you ask for certain things are required of you, and if you do not provide those things that are required of you, you risk having your matter dismissed. None of that occurred here.
Well, and so you're talking about the court's original order that dismissed that dismissed with prejudice because 5 months had passed.
Yes, that the
And
5
that you
months.
filed objections to.
That's correct.
So, I guess I'm wondering, with that fact, that if your objection was the court shouldn't have dismissed it, right?
Yes, with or without prejudice. Our position is the court should not have dismissed it.
Okay. So that would take you back to status quo then?
It would take us back to status quo in terms of what was pending at that time.
And weren't they in counseling at that time?
Pardon me?
Weren't they in counseling at that time?
They were in counseling. They were finishing up. They were supposed to do 10 counseling sessions.
So where's the prejudice? Because if you're taking back to status quo, the counseling was going on anyway, and all the court did was say, you're right, it should be dismissed without prejudice, and you can refile, and counseling should be ongoing, because that's the way it was before.
Counseling wasn't ongoing. Counseling was ordered for 10 sessions only.
I'm talking about at the time whenever the court dismissed it with prejudice, and you objected and said you shouldn't be dismissing it with prejudice.
That's correct, and we objected on 2 grounds. The first was that the court's order was 10 counseling sessions, and the parties were just about to enter into the 8th counseling session when the dismissal came down. So they hadn't even been able to meet, if you want to call it, a condition precedent. Actually, what the order said was 10 counseling sessions before you come back to court. And they hadn't finished even the 8th when it was dismissed. So our position is we wanted to finish the 8th, 9th, and 10th, and then have an opportunity to see where we're at. Do we continue counseling? Is this working? Actually, what we learned is that within the counseling sessions, father and the boys determined that if after 10 counseling sessions, either party determined that they no longer wished to have counseling, then counseling was going to end.
So.
And then we got it, pardon me.
That's okay. I'm just trying to figure out then, that's what I was getting at, the counseling hadn't ended.
It hadn't ended. We
So
only
the
had
court- and the
two.
court said then, okay, counseling shall be resumed. And you're objecting to that, though. Maybe I'm misunderstanding, maybe you're not objecting to the counseling, but I thought that was part of the reason why you're saying you're prejudiced because of ongoing counseling.
And I understand that. And that goes back to our argument that the court left us with no roadmap as to this counseling. Was it to continue until the 10 were completed? Was it to continue in perpetuity?
I'm confused. I thought you said just a while ago that the parties wished counseling to continue. Did I mishear you?
Yes, Your Honor.
Okay.
There is an issue as to whether counseling had the impact needed, whether the counselor was, this is supposed to be family counseling, and they left mother completely out of it. Okay, so there was a question about whether.
Okay, I understand now. I just misunderstood what you had said earlier. Thank you.
Okay.
And I hope I did not misspeak and mislead you, Your Honor.
No.
And you have reached the end of your allotted time to argue this morning. Thank you very much.
No, I was just saying too many questions, I'm sorry.
No, that's fine. Thank you. I appreciate the questions. Good day.
Thank you. The court will take the matter under advisement, issue a written decision which will be mailed to both sides, as well as posted on our website and the Ohio Supreme Court website.
Thank you very much.